really winter, isn't it? Christmas is coming. Yesterday I was in the middle of a discussion about the events immediately preceding the shooting of Mr. and Mrs. Menendez. Now, I am not going to go through all of these facts for the simple reason that when it came to describing these events, Erik was cross-examined repeatedly and repeatedly and repeatedly. And so there was a great deal of testimony and going over these events when he testified, and I don't think I need to remind you of that by repeating it all now. But what I am going to focus on are what were the significant events that kept the level of fear that had started on Tuesday and reached its height prior to Friday, Thursday night. And what was it that the parents did or didn't do that maintained and escalated that level of fear in this child of theirs that they had created with fear? Now, we were talking yesterday about that point when Erik is in the den or the family room, and his mother, who clearly knew in advance that there was going to be a confrontation, first with Lyle and then with Erik, admits to him that she knows and has known all along what's going on. Now, the prosecution tries to use the fact that this family has a maid to impeach the credibility of Erik and Lyle on some of the issues in the case. And here, for example, Mr. Kuriyama has already argued, and I suspect will argue again, that the maid didn't testify that she heard any yelling from this den. Yeah, but Erik didn't testify that there was any yelling at that point. He exchanged a few words with his mother. The only time he raised his voice is when he said to her, "I hate you." He was so shocked by her betrayal, and he ran out the door. But Mr. Slotkin testified that that particular room in the house, that family room, was soundproofed on purpose when the house was built. And when the Menendezes moved in, they put in bookcases that you can see from the photograph that I showed you yesterday that has all the boys' trophies along the top. And so, and this is by now like the middle of the night. This is after midnight because Mr. Menendez has come home very, very late that night. So I don't see any value whatsoever in the notion that the maid didn't hear Erik say, "I hate you." And then he ran out. And Lyle testified he could hear his mother screaming at Erik as they were right below the stairs at the guest house. And that's when he heard sounds from outside that attracted his attention to the stairs. Now, I had mentioned to you yesterday that if you analyze what went on in this family over that last summer, from this perspective of what are the parents doing here, it appears that they had declared war. The laboratory experiment had not succeeded in the way they hoped. And their behavior during this last week appears to be a declaration of war against their children. And this is what Mrs. Menendez says to Erik in that family room is as bold a declaration of war as you can imagine. I mean, to tell him, guess what? I know, and I didn't care. It cannot get worse in a parent-child relationship than for a mother to tell that to her son. And the fact that she would do such a cruel thing is not out of context or out of character for her. Because Tuesday, that argument with Lyle, we don't know exactly what it was about, except that it was about his hairpiece. I mean, and is that an appropriate thing to do with your son, to tear off his hairpiece? Let's say she's angry with him over something, or she doesn't want him to have a hairpiece. I mean, it is a sadistic thing to do. There are many ways to punish a child for whatever the sin is that she's punishing Lyle for. And you've heard about all the things that they were doing for him. They're buying him a condominium. He's going back to Princeton. I mean, there hasn't been any testimony in this case, but you can imagine what it costs to put a kid in an Ivy League school. He has this humongous credit card that he can use. I don't mean the phone credit card. I mean the one he bought the Rolex watches with. So if you're trying to punish him, there are lots of things you could cut him off of. But to rip this thing off, to attack his sense of self-worth, to attack his soul again. And that is how these people attack their children, in their heart and in their soul and in their sense of self-worth. We're not talking about normal parenting here. We're not talking about taking away privileges. We're talking about destroying the person, attacking their ego and their sense of themselves. Now, Erik has testified that when his mother admits what she knew, and he has this overwhelming sense of betrayal, he said, "I thought I didn't know her. I didn't know who she was, and it was very scary." And I talked yesterday about how you would get the sense that your parent is not at all the person you thought they were. Whatever you thought of her, she is like an alien now. But there were other things happening in this family that made this mother a very unsettling figure to her children. And I'm not even talking about that whole long history of her emotional and mental problems. I'm simply talking about behaviors that had no explanation, because this is a family where nobody ever shares anything with anybody. Erik testified that after his parents were dead, he discovered a tape recording device. And in fact, we put it in evidence, the hookup device, so that his parents were spying on all of his and Lyle's phone calls. They had this hookup for his phone. Now, that's a normal response of the parent of a teenager, is to spy on all of their phone calls. And he also testified that all of his diaries kept disappearing. That's a nice, appropriate parental tactic, steal your child's diaries. This shows respect for them as human beings. But beyond that, Erik said he had this sense that his mother had some kind of superhuman or magical power, because she knows everything. Well, she's reading his diaries, she's listening in on the phone, but he doesn't know that at the time. She knows when he doesn't want to tell her exactly who he's playing tennis with, or what girls he's met, or who he's going out with. She knows it anyway, and he can't figure out how. Now, you may say, oh, it's not reasonable for him not to have figured out how. But this is a child who was raised by a man, for example, who thinks that because he has his genes, he should be able to speak Spanish. There is a lot of very fantastical thinking that goes on in this family over the entire life of this child. So it is not out of context that his mother seems to have this uncanny ability to know what he's doing. And that makes her scary as well, besides all the specific things. And he said that he believed that his mother would kill them because she hated them, and she and Dad were a team. And he said she must have hated me for her to have known all those years. And I want to address briefly this notion, which is a completely accurate one, I think, that Erik had, a totally reasonable one, that his mother and father were a team. Excuse me. They had a joint style and a joint philosophy of child rearing. And that style and philosophy was that their children were not human beings to treasure and to love and to support and to appreciate for who they are, but they were objects to use for their own purposes. Their purposes of sexual pleasure, of sadistic pleasure, they loved to frighten them, together, to vent their frustration and anger on. And that was mainly Mrs. Menendez's use for these kids, to manipulate them and direct them and control them. For what purpose? Because they wanted the best for them, or for their own self-aggrandizement, for the trophies. And this is regardless of how the children feel, regardless of what the children want. And they are joint in this. And this is the pattern of his entire life. So during this last week, there is no reason for him to believe that they are now of two minds when they have always been of one. But more important, it is clear in the way that this family was organized that Mrs. Menendez was within the circle of the father's approval, from what the children could see, because she is totally loyal to him. My mother would never go against Dad, and there isn't a soul in the world who could come in here and testify that she would ever go against him on behalf of the children in any way. And he, as the kind of power-oriented person he was, certainly would not tolerate any force standing between him and his sense of ownership of these children. And I think, too, when you hear the stories about how she makes up ways for the children to get in trouble so that she won't, it's clear that her position was that Jose was going to vent, if he was going to vent his sadism, better on them than on her. And this is the pattern of their whole life. And it gets worse for the children's sake after they're in California. Because even though she's unhappy and she's miserable and he's done her wrong, this doesn't, there's those first few months, the months in which the sex stopped. There's those first few months, but after that, they are closer than ever. And everyone comments on how different their relationship is. Now, I have suggested to you that she has a threat that she's holding over him. But beyond that, how it appears to Erik is that his parents are one moon unit. There is no differentiation between them now at all. Because and her loyalty to Jose in view of the fact that he'd done her wrong, has got to convince Erik that she believes in everything he's doing. Because you would say, wait a minute, Dad was bad to her, therefore she should be mad at him, therefore she shouldn't be going along with everything. But the fact that she goes along with it even more would tell the child, well, she agrees with these things. She may have her personal differences with him, but when it comes to us, they are totally of one mind. And so all the threats that Jose ever made to Erik about killing him are equally ascribable to Kitty in this time of crisis, when she clearly takes no part other than Jose's part, which the children understand is her position as well. Okay, so this is the confrontation that Erik has with his mother Thursday, and then he goes up and he has this long talk with his brother, and the decision is made that they should do something to protect themselves, because they cannot conceive that these people would ever allow them to be free of them with this secret, would ever allow them to tell anybody. Now, you've heard a great deal about all the gun stores and buying the guns and the ID and all the rest of that. What's significant, though, in this course of the fear is the Friday night conversation when they come back. And this is where they had the conversation where their mother tells them that the time of the boat trip has changed. And so if you think about the fear over the course of that week, it has moments when it's very high, like Thursday night, and then Friday morning when the sun is shining, it comes down a little bit, but then it skyrockets right back up again. And never do the parents do anything that settles or resolves the issue or takes away the threat that this crisis poses for the children. The fear never, ever goes down to ground zero again. And Dr. Burgess talked about what happens over a course of days with someone like Erik, who has been raised on fear, who is extremely sensitive and hypervigilant to fear, and how he stays up at that elevated level all the time. Now, the thing about the boat trip is very interesting. The very fact that they went on it. The prosecution, I think, would argue that they're separated from their parents because they're up in the front of the boat getting soaking wet, conspiring. But that's ridiculous. I mean, if they're really planning to kill their parents, then why are they going on the boat trip at all? They could use their time better in creating real alibis rather than this patched up job that they came up with after the shootings. So why are they there? They testify they go because they don't want to do anything that will precipitate action on the part of their parents. And I think the other reality is they go because they do what they're told. There's a family boat trip, they're supposed to go on it, they go. They do what they're told, just like they always have. Now, after the boat trip, when nothing happens, in a sense, the fear level drops a tiny bit at that point, and there are a series of conversations between Erik and Lyle. But what's most significant is they go back home after talking at UCLA about what they should do the next day to stay away from the parents and to protect themselves. And then they have this argument with their mother when they're trying to get back in the house. And during the course of this argument, she flat out accuses Erik that, in her typical fashion, I mean, this is not out of character for her, that if he had kept his mouth shut, obvious reference to talking about the molestation, things would have worked out in the family. And what that tells Erik is, Mom is definitely hostile to us, wants to kill us. Things have not worked out well. These kids know if things are not going to work out, it's for them that it's not going to work out, not for the parents, that the parents are going to protect themselves from the threat that the children pose with their secret. And so he tells you that made it clear to him that both parents were resolved, that they had made up their mind, and that they were going to kill them. Now, we talk about these things, and none of us were there, and none of us lived the life that he lived. And you say to yourself, oh, that doesn't make sense. Oh, that's not reasonable. And all I can remind you of is two things. Number one, I'll get back to the law in a minute, that they don't have to be reasonable in order for the law of manslaughter to apply. That's part one. But the other part is, when you look at the whole pattern of behavior of these parents over the lives of these children, how unreasonable is it really to think that people who were this brutal and cruel to their children are incapable of killing them to protect themselves? I mean, you really have to say, is it unreasonable? Well, okay, it doesn't have to be reasonable for the law to apply. But is it totally fantastic, given the history of this family? Now we get to, Erik is gone all day long on Sunday, and Lyle is supposed to assess the situation. And we put on a lot of expert testimony about how frightened people, people who have been conditioned by fear, scan their environment. We did that from the very beginning with Dr. Briere in the hopes that you would then have some kind of framework for the rest of the evidence as it came in. And Dr. Briere is not personally involved with Erik. He's never talked to him. He was just here to explain general patterns, consistent patterns that happen in situations where people in power are abusing and battering people who are not in power within a family context. And he told you that this classic pattern of hypervigilance and heightened fear is a symptom of abused kids, just like it is a symptom of battered wives. And so what these folks do is they scan their environment for cues and for clues. And you might remember even on the tape of 1211, Lyle makes a reference to a word here and a word there. And these things have great meaning to a person who is watching to see if a threat is going to be actualized. Even though this word here and this word there wouldn't mean anything to us. And what's so strange about this family, what's so tragic about all this, this is, there are no winners and losers in this ever. There are only all losers. But what's so tragic about this is here are two articulate, intelligent, well-educated people, Mr. and Mrs. Menendez, with talents and abilities. He is a genius when it comes to business. He is clever. He's got a great way with words. She is a well-educated person. She was a school teacher. She is articulate. She is bright. And they cannot and will not talk. They will not talk to their children. They will not negotiate with them in any way, shape, or form. They will never give an inch. It is always going to be ultimate confrontation. And this entire situation could have been avoided with a word or two. How about, I'm sorry? How about, I'll stop? How about, we'll work on it? Anything. But no, they are so totally locked into themselves and what they want out of life and what they want out of the family. And they are so locked into the notion that their children are not people, that they are only a part of them and they don't have to be dealt with that way, that this thing ratchets into this monumental tragedy. And Sunday night starts this exchange where the brothers decide they want to leave and they want to stay away. And they go in order not to alarm the parents and tell them we're going out now, and they're told they can't go out. And their mother is acting very peculiarly because she won't give them a reason. Because there is no good reason why they can't go out. There's no school. It's summertime. They don't have to be anywhere. There's no reason why they can't stay out late. And they haven't done anything over the course of the day to be punished about. So it makes no sense when they're told they can't go out and they have to be there. And then starts the argument where it is clear to Erik and Lyle that Jose is sending Erik to his room for a very ugly purpose, and that these parents are now at the verge of making good on their lifelong threats. Now, it might not seem that way to us, but it seemed that way to them. And what happens at this point, you can analyze this. You can try to analyze it logically. You can try to analyze it scientifically, but human emotions are not really measurable that way. And Mr. Kuriyama and Mrs. Bazanich, too, when she was cross-examining, have been very derisive about the research that Dr. Burgess talked about, where there was research done on a type of snail in order to see if you could actually see under a microscope in a testing situation a change in a brain brought about by trauma. That's what that research was about. And we do not do research like that on people. We do not cut open their brains. We don't traumatize them first and then cut open their brains to see if we can see physiological changes. We do that kind of research in a scientific setting on lower organisms than human beings. And as you know, there's a lot of people who think we don't do them on organisms low enough. There's animal rights people who are very upset about experimenting on animals in laboratories. But all she's talking about is the fact that current neurobiological research is confirming with physical evidence that traumatized organisms have a rewiring in their brain. And whether that's a biological reality or the psychological reality that those who have studied traumatized people have known about for years, the fact of the matter is there is a point if you have been traumatized most of your life when you go over the edge, period. And that is what happened that Sunday night to Erik Menendez. He had been living with this fear. It kept getting higher. The cues and the clues that he saw based on his whole relationship with his parents told him, they're going to kill me now. And he was terrified. And he went over the edge. Now, we can talk about it in the terms that Dr. Burgess did about the fight and flight response, which is automatic, which does not involve the cerebral cortex, which is the part of the brain that does rational and logical and deliberative kind of thinking. Because and she described it in a sense as automatic pilot, which is not a scientific term, but it conveys the same meaning. But the point is, if you think about it, if you're driving down the street and a truck cuts you off, okay, you hit the brake, you hit the steering wheel long before you don't have to think about hit the brake. You don't think I intend to hit the steering wheel. You just do it. And it is only after the truck has passed and look, you didn't get hit and you're not dead, that you start to process what just happened. What just happened? The truck came from here and I did that. Gee, I don't even remember hitting the brake. And your heart starts to calm down a little bit. And that is the classic fear reaction, and that is the classic automatic movement. Well, it doesn't only take place over the space of a few seconds, as in a near accident. It takes place as well during any highly fearful, traumatic episode, which is what's going on in this house that Sunday night. And here's the other aspect of tragedy here, that this fear at this point is not rationally developed, is not thought about, it simply takes over, and it is uncontrollable. There is nothing when you are in that mode as a person that you can do or say to your body to say, stop reacting with fear. Don't react with fear. It's going to do it. You have no control over it. And the tragic part is, just to go back to my analogy of the scientific experiment, the laboratory way of raising these children. Control was the key to how Jose and Kitty Menendez raised their children. They probably thought they could do anything they wanted to them, and so long as they were perceived as the powerful ones, they could control the outcome. But the kids themselves couldn't control the fear. It got out of control, and this was something I don't think either Mr. or Mrs. Menendez ever anticipated, that if you terrorize a person so much, they're not going to be able to cope with it forever. And all their coping strategies and all their coping mechanisms that Erik developed over all these years simply left him when survival was on the line. And he couldn't control it, and the parents couldn't control it. And by maintaining this wall of silence and rejection that whole weekend, they lost control over Erik forever. They couldn't, if they had just reeled him in with any comforting or supporting talk of any kind, that fear would have disappeared. But they were going to play it power to the end. And in the end, they lost control over a situation that they created. It's as if in this laboratory, they had taken hydrogen and chloride and poured them in a dish and created hydrochloric acid and got burned. The acid didn't ask to be created. He did not ask to be born to these people. He did not ask them to treat him that way. He did not ask them to hypersensitize him to fear. They did that on their own, and the experiment got out of control by their doing. Now, am I blaming the victims? No. I am understanding what happened, and that's what I'm asking you to do. The interesting thing, too, that Erik testified to about when he rushes to get his gun and they've loaded the gun out by the car, is what it was the only thing that was going on in his mind was hurry up, hurry up. He's got to get to that room before they get to him first. And he says that based on his entire experience of confrontation with these parents, he knows that if he's actually confronted with them, and he believes, remember, at that point, that they have to be arming themselves in some way, that he would have been frozen. He would never, and he never was able to have a direct confrontation with them. We have 2 words, shut up, over the entire course of his life. And he felt, rightly so, that he would never have been able to defend himself at that moment, that once they were in operation right in front of his eyes, he would have been frozen, like the bunny on the highway with the headlights on. And then he talked about what actually went on inside the den during the shooting. And he was cross-examined repeatedly over and over. Well, what did you do? And what did you see? And he says, and it isn't hard to understand, he doesn't remember doing anything but firing the gun right ahead, because he didn't do anything but that. He walked into a darkened room. He starts firing a gun that produces a great deal of smoke. All he remembers is running, and he remembers where he wound up, and he remembers firing right in front of him. And he doesn't remember any thinking at that time, because as we know, this is not a time when you do any thinking of any kind. And that's it. What else should he remember? What was on television? What was on the coffee table? No, that he blew 2 rounds through the back window? No. You wouldn't expect to remember that if you're doing this in that state. Suppose if you're a cold enough and calculating enough killer, you will watch to see where each of the 27 pellets from the buckshot round goes. Of course, you couldn't possibly see that anyway. You can't really see that happening, even if you are looking to see it, and I think it's clear he wasn't. Now, what he did testify to about what he remembers seeing when he first got in the room was that his father was standing up in front of that portion of the couch that was beyond the coffee table, and that his mother was standing between the couch and the coffee table. And I'm putting up a crime scene photograph of Mr. Menendez's legs. Now, I will deal a little bit later with Mr. Signorelli's testimony and the facts that the prosecution are relying on. He's here for one tiny little purpose, and I will get to that. But Mr. Kuriyama reminded you that part of his testimony was that Erik supposedly told him on the 1st of September that when he entered the room, his father was seated on the couch. And I believe the prosecution wants to argue, indeed, that that was true, that Mr. Menendez was shot on the couch, and that he is in the position in these photographs that he was in throughout the course of the shooting. And I will tell you flat out that isn't true. Not only could they not prove that, but they proved the opposite of that. There is some physical evidence in this case that is not ambiguous. And the evidence from the coroner and the evidence of your own eyes here is not ambiguous. And here's the point. This is the left thigh injury. And this is an arrow that the coroner, I believe, drew on this photograph, which shows the direction of this shot. This is the entrance wound. This is the exit wound. It goes from inside the top of his left thigh to outside the top of his left thigh. And there's the direction of the shot. And he could not have been sitting when he received it, because you can't tell from this photograph. You can tell somewhat from this photograph, but it's a through and through wound. The pellets pass through completely. There is no blood splatter here. There is no blood splatter on this side of the couch at all. And if something goes through there, there would be. There has to be. The blood splatter and or the pellets, if they come out, on this side, in this area, and there is absolutely nothing there. So the coroner testified, no, he could not have been in that position at the time that that wound was inflicted. But that wound is consistent with his standing up. And if you look at the other crime scene photographs, and you will have them all, what is most consistent, the explanation for what position he was in, is if you look at the couch behind him, there's a tremendous amount of blood there. And Detective Zoller testified they did not attempt to dig pellets out of the couch. So there is this very bloody area in the couch that potentially holds pellets. But if Mr. Menendez, see, this is the couch. If Mr. Menendez was standing in such a way as this and was shot in this direction, then the back of the couch, the seat of the couch where all the blood is, would have the spray from that wound and the pellets from that wound. And that is the only place, and you just look at the photographs, I mean, without the bodies on them, they're not as gruesome. Just look at the photograph on the couch and you will see that it is impossible for him to be seated in order to receive that wound, to be seated in any way to receive that wound. Beyond that, he also has wounds to the back of his arm, okay, and I believe it's the right arm. And the coroner testified he could not possibly have received those wounds to the back of his arm if he was in the position that he's in, because you would have had to shoot right through the couch. And he would have seen evidence of that. First of all, you'd have to go completely around the couch and shoot behind the couch to get those wounds in his arm. And there was no evidence from the pellets. They didn't pick up any fibers or anything like that in those wounds. So clearly he was in a completely different position when he received both the leg wound and when he received the wound to his arm. And what's consistent with those wounds is that he was standing up and he was moving. And you may recall Lyle testified that he saw his father moving towards him, which is consistent with what I have shown you, where the evidence of that wound would be on the seat of the couch or on the back of the couch. Now, much has been made by the prosecution about this route that was taken after the shootings, what Erik testified. Well, no, much has been made about what Lyle testified to. And one of the things that was done here, and I talked about this earlier, is the prosecution simply selects those bits and pieces from the defense case that they like and ignore the rest. And they didn't just select, they did an entire elaborate driving route based on what they say was Lyle's testimony only, and they didn't even do a driving route based on what Erik testified to. And I just think that's intellectually dishonest. And then Mr. Kuriyama gets up here and talks about, well, Lyle said they stayed 5 to 10 minutes and blah, blah, blah. Well, the fact is Erik didn't testify that way. Erik's memory was different. And the memory of someone after a trauma like this as to time is probably the least reliable thing for anyone to base a decision on. But the fact of the matter is this is Erik's trial, and Erik testified that in his recollection, they remained in the house only 3 to 4 minutes after the shooting occurred. And they didn't take long at all to pick up the shells in the family room. And he pointed out why, because they were all in one general area and they didn't have to go hunting around to find them. And the times that Miss Erdely put on the charts, and you will have the charts, not the big ones, but the small versions of the charts in the jury room, are not what I told her to do arbitrarily or what she figured out to do arbitrarily. It's what Erik testified to. And every segment of that trip, the time for activities, is what he testified to. And she drove it, and it was doable. Not only was it doable to do the drive in 50 minutes, it was absolutely doable to do all the activities he testified to in the time he said it took, and she did it 4 times, and for both routes. The reason we did 2 routes is in order to give a fully balanced picture, because Lyle testified that he thought they may have dumped the guns first. And so we did a route with dumping the guns first. And it turns out there isn't much differential in time, whether you dump the guns first or you go to the movie theater first, because Lyle's route didn't involve the freeway and Erik's route did involve the freeway. And when you factor those differences in, it comes out to be the same thing, 51 minutes. And so we sent someone out there who did a meticulous and carefully documented route. You have the videos. I can't imagine you're going to want to take 2 hours because there's 2 different routes to play the video, but you've got all the time in the world. There's no limit on how long you can deliberate except your own tolerance and patience. And so if you want to play the videos, I invite you to compare the video that Ms. Erdely made and carefully documented with the thing that Detective Zoller and his wife did. But the fact of the matter is, there has been no impeachment whatsoever of the activities after based on time or based on the route. Now, I want to talk about Saturday morning and Mr. Walker. Erik testified that Saturday morning, he and his brother went off in search of, for him, an opportunity to try out the gun, which he never got, and for his brother, an inquiry about ammunition to make sure they had the right sort. And they bought more ammunition, and they bought it at the store in Van Nuys that Detective Zoller confirmed exists and is exactly as Erik described it, a small little store with a target range across the street, an indoor target range where they don't let you shoot off shotguns. And the people put on the volunteer, Mr. Walker. And I would like to suggest an analysis of Mr. Walker's testimony on a number of grounds. Okay. Now, I don't doubt that on some day, under some circumstance, Mr. Walker fixed the spa controls or the pool controls or both of them, if that's what he was hired to do. And he may even have done that work on August 19th, though there are no records of any kind, nor were they ever to prove that. Nor did the prosecution put on any witness who said that at that time, right around the time, Mr. Walker said, gee, I was just there 2 days ago, okay? They did put on Mr. Bartek, and Mr. Bartek impeached Mr. Walker. And what I mean by that is Mr. Bartek said, yes, I told Mr. Walker to do this, and yes, Mr. Walker said he did this, and yes, I paid him, and maybe this is the check, and maybe this isn't the check that I paid him with. And yes, he told me his story about what he saw. And what was it that Mr. Walker told Mr. Bartek? He said that Mr. Walker told him he oversaw an argument. Mr. Walker told 5 different versions, I want you to know. So I think the version that Mr. Bartek testified to was that Mr. Walker told him that he had seen the younger son having an argument with the father. Now that's the story that Mr. Walker at some point told Mr. Bartek, okay? But what he told you here his testimony here was that Kitty and Jose and Erik Menendez were all around this table and chairs, which wasn't here, but here, between the tennis court fence and the pool. That's where he told us they were. And they were there, and there was no fence here at all. It was totally an open space, he said. And Lyle was on the tennis court with his coach, and Lyle was using foul language because he missed a shot, and he was in a fight with his mother. He was using the foul language of his mother. That's what he testified to here. On the radio, he said, Erik is on the tennis court having a fit because of the missed shot, using foul language, but he doesn't say that it's directed at anybody, mom or dad. And he says the parents on the radio, he says the parents aren't saying anything. Okay? And then, of course, we know Bartek says the fight was between Erik and dad. And here he says the fight is between Lyle and mom. Now, this is not if this is true, this is not a very hard story to repeat. But what's interesting about it is many things. First of all, he says the coach is there. We know there's only one coach at this point in their lives, and that's Mark Heffernan. And we know Mark Heffernan isn't there specifically because Mark Heffernan says he knew they were going on the boat trip on Saturday, and he knew that definitely Saturday he wasn't giving them a tennis lesson, and he was expecting a call on Sunday. Maybe there'd be a lesson that day, okay? So the coach is definitely not there. So he's made that up, okay? Now, he's also made up something that's contrary to the history of the family and contrary to what everybody knows. And that is that Kitty Menendez is not the one, when one of the boys is playing tennis, to make these comments on their play. And he is claiming, Mr. Walker, that what is going on is whichever brother it is, and whatever it is he's doing, because I don't know anything about tennis, I can't tell you. Well, did you tell the police that they missed a shot? Well, I don't know about missing a shot. I don't know anything about tennis, I can't tell you. And on the radio, he says, missed a shot. And in Detective Zoller's report is written, missed a shot. But here, well, I don't know enough about tennis to tell you if they missed a shot or not. Okay. All right, but my point is, Kitty is not the person to be commenting on how one of the boys plays. That's Jose's job, and that's what he's been doing all of their lives. And yet Mr. Walker tells us Jose is silent. Kitty's the one making the comments. And now it's either Erik or Lyle, or the interchangeable people. It's one of them is now saying something foul back to Kitty. And I submit to you that none of that ever happened. Okay? And here's the clue to that it never happened. Mr. Walker, he didn't want to get involved. He didn't want to be here. He's not seeking publicity. He doesn't want his voice and his visage known. Oh no, he's only here. This is before we knew about the radio program, folks. He is only here because his wife, without his permission, went to the police department and told them that he knew something about this family. Now, when is it that Mr. Walker goes to the police? July 25th. When did this trial begin? I'm sure you all know only too well. And what did we talk about in opening statement? Our entire theory of the case. And who testified on July 21st? Bob Anderson, the boat captain, talking about how this family appears to him. And on July 25th, Mr. Walker goes and gives his little story to the police. What Mr. Walker also tells us, though, which is also a clue that he is not credible, is that since he saw this remarkable event, a teenage boy, or maybe a slightly older boy, since we don't know who, saying something rude to a parent, since he saw so remarkable an event, he called the Beverly Hills Police Department as soon as he heard they were dead. That's what he says. And he told Miss Erdely that when he called, he left his phone number. And here we have the desk person at the Beverly Hills Police Department. This is the biggest criminal investigation, as you can imagine, in the Beverly Hills Police Department's recent history. I mean, the only thing that even got anything like the coverage of this was Zsa Zsa slapping the cop. But this is a double homicide at home in the fair and perfect city of Beverly Hills. And here is a person calling in immediately saying, I have information on the Menendez case, and they don't want to talk to him. Because he says, the person who answered the phone says, no, well, that's not important. We don't need to talk to you. And he tells Miss Erdely he leaves his phone number, and they never call him back. And Detective Zoller says there's no such message. So that's a clue that he's not telling you the truth. And the other clue that he's not telling you the truth is, when do you suppose this photograph was taken? Sunday. This is one of the crime scene photographs. And this one too. When do you suppose these photographs? These are taken by the Beverly Hills Police Department. The next day, the table and chairs have miraculously migrated back in front of the guest house and are not where Mr. Walker claims they were. And as I said to you in the beginning, one of the really bad aspects to having a totally televised trial is the homework people can do to come in and make up stories. Now, there's another way to look at why Mr. Walker did this. You know, he's a person who lives an ordinary sort of life, and this was a big deal, the killing of the Menendez parents. And he serviced their pool. And you could see him saying, I service that pool. I know all about that. I know those people. In fact, I even saw them. And he may have been foolish enough to tell his wife, hey, you know, I serviced that spot. Well, what'd you see? Were they home? Did you see them? Oh, yeah, they were there. Well, what did you see? Who knows when he first made up the story, either to impress his wife, who clearly wanted the exposure of this trial since she went to the police department, or whether he told less, like I was there, and the details only fleshed out after we started this trial. We will never know. But the story is so out of context for what we know about this family, and it is so uncorroborated by the physical evidence that I just find it untrue. And beyond that, the most important, because you know the prosecution's whole theory is Erik Menendez has lied about every single thing he said on the witness stand. Everything. All right, across the board. In fact, the molestation is so ridiculous, we won't even ask him questions about it. And he had lots of opportunities. He was there for 10 days to lie. And he testified that he knew about Mr. Walker. He said, I know there's someone who's going to come in here and say he was at our house that morning. He knows. We know. We get reports. They're not allowed to hide stuff. And so when Mr. Walker volunteers, we find out about it shortly thereafter, months before Erik Menendez ever took the witness stand. And how hard would it be to say, we went and we bought ammunition, and then we went back home and we played tennis, and then we left on a boat trip. But remember, Mr. Walker says he's there at 2 o'clock, and he's there for 45 minutes. And they're supposed to leave on the boat trip, according to Mr. Anderson even, at 3 o'clock. And yet no one is making any effort to prepare for this trip. Everyone's just sitting around letting the kids cuss at them. That's what's going on. And Erik knows this testimony's coming And he could easily reconfigure his story if that's what he was going to do. And he didn't. And he also knows, obviously, that Mark Heffernan is going to say that he believes, although he has no schedule to prove it, that he gave him a tennis lesson on Friday rather than Thursday. But Erik remembers what Erik remembers. And that's what he testified to. And along that same line, I will talk about the reloading that occurs after Erik and Lyle shoot whatever ammunition they had in their gun. They both go outside and Lyle reloads one round. Now, if Erik wanted to make himself look good, there's a lot of things he could have done with that evidence, not the least of which is forget it. But he could have lied. They both could have lied about that. There was no way in the world that the prosecution could have proved that they reloaded that one shell. There is no way in the world, because none of the neighbors heard a pause long enough to include that. When they testified, they heard what sounded like a string of firecrackers and then a pause of a second or two. Now, I submit to you, it did not take long to run back to the front and to load that shell in the panic state they were in, but it took more than a second. It probably took more than 5 seconds. And not a single person. And again, remember, we don't try cases in a vacuum. We know what people are going to say in advance. And he does too, because we tell him. He sees the report. So we know what the neighbors heard and what the neighbors didn't hear. And no one heard a pause that would account for the reload. And yet they testified to it. And there is no physical evidence that shows a reload was necessary. No matter how many times Mr. Kuriyama may talk about the number of wounds do not equal the number of shots. And they can only prove 8 shots. And I think there were more than 8 shots, but I don't think there were 13 shots, which is what they'd have to prove. There is no evidence to support that. And so there was lots of room to run if Erik wanted to lie, because they could never prove through physical evidence there was a reloading. But it happened. And he told the truth about what happened that night. They ran out, and that shell was reloaded. And that's that. And Lyle even testified that he had extra shells in his pocket. But he was in such a panic state, he didn't even remember that. And he could have lied and said, to make it look less disturbing, that he reloaded from his pocket. But he didn't say that. So, as I believe Lyle testified, when they knew that they would be telling the truth about their lives, they were going to tell the good along with the bad. And that's what happened. And it's for you to judge whether the fact of that reload in the panic condition they were in has any significance whatsoever. But the fact is, they told you the truth about it, and they didn't have to do that. No one would have known. As the prosecution was so quick to point out, which is so obvious, it's meaningless, but no, Kitty and Jose Menendez can't get in here and talk about how they molested and abused their kids. They would have never admitted it anyway, but no, they are not alive to refute. The problem is they couldn't have refuted if they were alive. The fact that these things happen is why they're not alive. Now I will talk briefly about Craig Signorelli. The purpose of Craig Signorelli's testimony has to do with the lying in wait special circumstance. And I have not gone in detail about the special circumstances, nor will I, because they're very, very long instructions. And I honestly cannot conceive of us being there. Maybe you can, but I can't. And if we are, I think you can follow the instructions without my having to take you through it. But there's a couple of important components about the lying in wait special circumstance. Mr. Kuriyama talked about some of it, but he left out this part, that there has to be proof of a substantial period of watching and waiting, not just a look or a peek, but a substantial period of watching and waiting, and then taking action in a continuous from that period of watching and waiting in a place of concealment. And that's what the law requires. And their entire purpose in putting Craig Signorelli on the witness stand was for him to testify that he remembers, never having written it down, mind you, he remembers that Erik said that he peeked in the door and saw his father sitting on the couch. Now, we know father wasn't sitting on the couch from what I've just shown you. But beyond that, how do you analyze that testimony? First of all, as you know, Craig Signorelli first tells this story on November 17th. 1989, to Detective Zoller up in Santa Barbara at the Baker Square restaurant. And when he tells him the story, he tells him that when Erik tells him this story about him and Lyle shooting their parents, he tells it in such a way that it's not real. He says he conditions it. It could happen. He tells it like a mind game. He is spinning a story. That's what he tells Detective Zoller on November 17th. And nevertheless, and he tells us now, I did that because I didn't want to bring down my friend. But 12 days later, he's wired for sound by the police, and he was very loath to tell us how they wired him up because, after all, that's police procedures. Am I permitted? He turns to the judge. Am I permitted to talk about that, Judge? That's police, little junior G-man on the witness stand. Well, okay, yes, you can tell us how you were wired up by the police, Mr. Signorelli. I know you're very important, but you can tell us anyway. And so here he is. He didn't want to bring down a friend, but he wants to get him on tape for the police, because I suppose it'll make a better chapter in the screenplay that he told Mrs. Cohen he was writing, or in the book that he told Doug Doss he was promoting, which he hoped to make $1 million off of. So I suppose he thinks this will be very useful to his future as a senator. He, by the way, is the one who's majored in theater arts in college, and he tells us he did that so he can star in his own political commercials. So I guess this is a dress rehearsal for his political commercials, young Mr. Signorelli. Mr. Signorelli, I suspect, is a rather troubled youth. And this is a case about troubled youth. So in spite of the fact I'm being kind of sarcastic about him, I think he's a very troubled youth. And let's leave it at that. But the fact of the matter is that he comes in here and he testifies. And, well, let me go back to November 17th. On November 17th, when he tells Detective Zoller that Erik tells him this story, he doesn't say anything about the computer people. Not a word, okay? He doesn't claim to have been there on the day the computer people were there. That piece of his story does not emerge until March 7th, 1990. Now, what has happened between November 17th, 1989 and March 7th, 1990? Well, maybe he hasn't gotten a good enough offer on his book or on his screenplay. But the other thing that's happened is he's wired himself up, and he's gone out to this dinner with Erik, and he has tried his best during the course of that dinner to get Erik to talk about killing his parents, or to get Erik to talk about anything that would sound negative. And he is the one who suggests that they should talk about a company like the BBC. Those are Craig Signorelli's words. And if you want to hear that testimony reread, you don't have the transcript, but it was a very poor quality tape. But you can hear his testimony. It is he, and between him and Detective Zoller, this thing was patched together for you by way of testimony, who suggests when Erik is talking about dreams for the future and a company that would do apparently everything except fry fish, that Craig says, you mean like the BBC? Okay? This is Craig talking. You can see why a kid like Craig would talk about things like that. I mean, he is a very grandiose young man. All right. And during the entire course of that conversation, he keeps trying to lead Erik into talking about killing his parents. And when he won't let go of the subject, and Erik testified about this at great length, line by line. And if you really want to know what went on in that conversation, I suggest that you listen to that portion of Erik's testimony again. And finally, Mr. Signorelli starts to talk about writing a screenplay about the killing of Mr. and Mrs. Menendez. And Erik says, don't fuck with that. And he says it over and over again when Craig keeps trying to bring up, but wait, we could talk, but don't fuck with that, he says. And then Craig makes some reference to the fact that Erik has talked to him about this before. And Erik says, I should never have joked with you that way. You know we didn't kill our parents. And why does Erik deny it now to Craig when he also testifies that he indeed suggests to Craig in this sort of not quite real way that he and Lyle were responsible? Because he sort of knows that Craig is talking to the police and he's suspicious of him, okay? And he sees that Craig is trying to lure him into making these statements. So that's where that conversation goes nowhere. And in fact, it goes so nowhere that at the end of it, Craig says to the police who are listening into his lapel, Gee, guys, I guess that didn't help you much. This is the young man who didn't want to bring down his friend, he tells us, okay? So let's go back then to what value there is in the statement he says he got from Erik Menendez. We know it isn't comport with the physical evidence, but beyond that, let's assume hypothetically Erik spun this yarn for him, which is what it sounds like. Did he get it right? Did he get the details right, Mr. Signorelli, when he's being told the story? He never asked any follow-up questions. He says that himself. He didn't ask why. He lied to the police on November 17th when he told them he wrote it all down in his school notebooks, what Erik had told him. So eventually, being conscientious policemen, they get a search warrant for his house to find the notebook in which he wrote it all down. And lo and behold, he didn't write it all down. They got the notebooks, and there's nothing in the notebooks about Erik's confession to him. And he sits here on the witness stand, Mr. Signorelli, and he tells you, oh, I didn't mean I wrote it all down. Well, he doesn't quite say that. He basically says he didn't tell Detective Zoller that he wrote it all down. I intended to write it down. I told him I intended to write it down. And I said, do you think they're going to issue a search warrant because you intended to write it down or because you told them you did write it down? Well, I told them I intended. I was writing it down. Well, blah, blah, blah. He lied to the police. He didn't write it down. And so how accurate is his recollection? And how trustworthy is his word? Now, he says, and we've gotten to an awful lot of litigation over a very small point, which is what happens in trials. He says that he was there when the computer people came. Erik says he was not, but I told him about it. And that, I suspect, is why he has such a strange story about them. Now, it doesn't take much to tell someone, yeah, a computer guy came and he had a pregnant wife. And he kept looking for this thing in the computer, and it took a couple hours, and he couldn't find it, and that's when I found out. This is Erik talking to him, I suppose. That's when I found out my brother had somebody there before who erased the computer. The whole business about erasing the computer has no significance with respect to Erik anyway, because he didn't do it. Okay, it's Lyle who did that, and Lyle explained why he did that, and even that has no significance because there never was anything in that computer that could have made the slightest difference. Something in a computer is not a will. Carlos Baralt knew that, discussed that with Lyle. The relatives who first found that file knew there was no information in the will. They tried to get it. Joan tried to get it. Pat tried to get it. We're all sitting there playing with the computer. So none of it has any significance. I don't know how many weeks of testimony went into this issue. That absolutely has no significance. But to get back to this, the Haymans, that very attractive young couple, came in, and he was the computer expert, and she was the once pregnant wife. And I'll tell you just a tiny story. When we went to interview the Haymans, all this happened, right, 4 years ago. We go to their house. There were 3 little kids.
Counsel, let's stick to the record here.
It tells you about the passage of time. In any event, here are the Haymans, and they tell us that they saw someone on television in one of these programs about the case. And you all, most of you saw something on television about this case as well before you became jurors. And they decided, or that person on television was the person that they had seen on the house, and that person on television was Craig Signorelli. But the problem with that is the way they described the person who was in the house. Now, Casey Whalen wasn't on any of the television programs. I don't think he wants to be a senator. He isn't majoring in theater arts, and he doesn't have as desperate a need to be the center of attention, so he didn't get involved with the television program. But he fit the description that the Haymans gave of someone who was heavier built than Erik, of someone who had sandy hair. Now, Craig Signorelli, there's been testimony, was smaller than Erik at that time, thinner, and always had pitch black hair. And when they talked about someone who was medium build, shorter than Erik, and light hair, that matches Casey Whalen and not Craig Signorelli. And the Whalen family remember that they were having discussions. Remember this dinner on Friday night. And his sister was absolutely clear it was Friday night because that was the last day she worked, and it was after work. And this was the Labor Day weekend, and she didn't go back to that job, okay? So they remember Casey and Erik talking about having been at the house and discovering that the computer had been erased. Now, There was all this confusion about whether Erik came back August 31st or whether Erik came back September 1st, and he testified on cross-examination. He's not sure when he did. And Pat Heffernan testified he was in a daze, and he left half his clothes behind in the hotel room, okay? And I don't know. Did he fly on the 31st? He went to the airport. The ticket was used. Did he fly on the 31st? Most probably he did. So, if that's true, how could, Casey Whalen have been there on September 1st? Because they went back the next day to get Erik's car. And I suggest to you, and you know, Casey Whalen had no particular reason these past 4 years until he realized he was going to be a witness this past summer. He had no reason to try to remember specifically what date. And what his mother and what his sister remember is that he did indeed pick Erik up at the airport, and that they did indeed have a dinner where the erasing of the computer was discussed. And Katie, the sister, can date that dinner. But that does not mean that the picking up at the airport and the thing with the computer had to have happened on the same day. And remember, Craig Signorelli gives no details why he can't describe the Haymans. He can't describe any conversation that went on between Erik and the computer person. He doesn't remember the phone call to Carlos Menendez that Mr. Heyman talks about, which was an animated and loud phone call, because it appeared Carlos Menendez was somehow blaming Erik, and Erik is explaining, I had nothing to do with it. You know, it's not there, whatever we were looking for. Craig doesn't remember it, and Casey doesn't remember it. Craig doesn't remember doing anything around the house when the computer people were there, and Casey doesn't remember it. It's not something anybody should remember the details about, okay? And their memory on that score is exactly the same, all right? So that doesn't prove who has the superior memory. And the only other thing, of course, is Craig then proceeds to tell you that Erik is telling him this story. I mean, maybe I would have been better off not challenging Craig Signorelli at all, because what does he say? Erik is trying to find a will that partly disinherits him. He claims that Erik told him, yes, I'm looking on this computer for a will that leaves money to the company and less money to me and Lyle and money to some third place. And Erik says he never told him that. That's one of Craig's creative writing exercises. He's a big-time creative writer, writes books, writes screenplays. In any event, that was the whole, and that is the whole, and that is the total significance of Mr. Signorelli, is this notion that he somehow informs the lying in wait special circumstance. But of course, he really doesn't, because he cannot and does not fill in the necessary element of a substantial period of watching and waiting. He also said, by the way, that he was at that house hours before the computer people arrive. And we know from Mr. Heyman's testimony with Erik, we know from Mr. Heyman's testimony that there was this crossed signal. He gets to the house, nobody's heard of him, Erik's not there, he goes away, he comes back, he calls again and he's told Erik has just arrived, and he gets there immediately. So that's inconsistent with at least the sequence of events. And then the other thing here, which I will point out, is this. He testifies, Mr. Signorelli, that he sleeps over that night, Friday night, September 1st, okay? And he testified that he slept over in one of the guest bedrooms upstairs. And you heard from Ed Fenno, there are a number of different colored guest bedrooms. His bedroom in the house was the gray bedroom. And if you look at the photographs, there are two other guest bedrooms. One of them has the animal fecal material on the floor that the Beverly Hills police took a picture of. And the last one, I think, is a room that's mainly, and that's a green and white room, and then there's an orangey type of room, okay? That's what his testimony was. Well, as you know, we went out in March and interviewed the security guard who was on duty overnight on September 1st. That was Antoinette Browers Loden. At that time, her name was still Browers. We interviewed her, Miss Erdely, who takes contemporaneous notes of her interviews and then keeps the notes and writes up a report. Went there with the work schedule, which is here. And she sat down with her and showed her the dates that she worked, and they're highlighted on this schedule in shocking yellow, and went through with Miss Browers the fact that she worked only one overnight shift at all during her whole time at the Menendez house, and that was the night of September 1st. And then she worked 2 or 3 morning shifts when she'd get on duty at 8 o'clock. And Miss Browers was very specific with Miss Erdely that one overnight shift, she remembered that when she got there, the guard on duty said there was nobody in the house and that she saw nobody in the house. And the next morning she saw nobody, meaning no family, only another security guard in the house. And she was real clear and real firm on that with Miss Erdely in March of 1993. And she also said that on one of her later early morning shifts, and her next early morning shift was September 7th, the following Friday, when Erik testified Craig was at his house. The following Friday, she remembers seeing a friend of Erik's there wearing jeans and a t-shirt. And that is what she said, and that is what Miss Erdely wrote down and wrote up in her report. And in comes Miss Browers, Lieutenant Browers, and gets on the witness stand and testifies that she hasn't seen her work schedule, and testifies that the night of September 1st, Erik had a friend stay over, and she saw them the next morning in robes and pajamas, and that's the new testimony here. As I told you, it's fairly revolting how many people will come into court and lie. But her prior statement, which was carefully recorded by Miss Erdely, her prior statement comes in as an inconsistent statement, and it comes in for the truth of the matter asserted. And you will be so informed that if you decide what she said to Miss Erdely is the truth, you can accept it for the truth and not just to show that she's given different stories at different times. And she claimed here to be very fuzzy in her recollections, and if you want to hear all of her testimony again, that too can be reread. Now, I want to just address, I've already addressed in my previous remarks the evidence that the people put on in their rebuttal case. And you can recall the marvelous start that case had with Mr. Valentine and then Miss Browers-Loden. And at some point, Mr. Walker, and then Uncle Brian, and Jamie Pisarcik. And I've already addressed Jamie Pisarcik, and I want to get back for a moment to Uncle Brian. I thought Uncle Brian was a fascinating witness because he couldn't and didn't contradict or controvert what we had already heard about his sister. But he tried to contradict what we knew about how his sister dealt with losing. I'm putting this up again because I want to actually take you through the testimony of Pat Anderson. Mr. Kuriyama relies on Pat Anderson to prove that Erik said shut up, and yet put on Mr. Anderson, who told a very different version of these events. I'm not sure I have my small version, so I'll read along here and swing the mic. Okay, now what's happening here is she's describing at the top of this how very, very upset Jose is getting while Erik is playing in this penultimate round at Kalamazoo. She says, and he was moving closer to the net, this is Jose, or the fencing. And with that, he was getting louder by giving his commands to Erik, and the officials were called. Now, Brian Anderson says Jose is doing nothing worse than just sitting in his seat giving these illegal hand signals. He denies that Jose is saying anything verbal. He denies that he's walking down closer to where Erik is playing. What the officials do, the officials came over and told Jose that he should sit down and he was not to be near the courts, that it was not permitted, and that he was not to give any kind of directions, that he was not to coach, and that he was the father, and the father knew what the rules were. The rules were to sit down and be very quiet. And did he sit down and become very quiet? Well, the official left, and Jose sat down for a minute, got up and left and did not listen to what he said, and proceeded to go back to the court area, which was right next to the court area there. Did Erik win or lose? He lost. What happened after he lost? There was one other incident that I should tell you about too, there that happened other. And Mr. Kuriyama objects. And the court tells me to ask a question. Not me, Ms. Lansing. And Miss Lansing says, was there another incident that was of significance to you? Yes, there was. Tell us what it is. What had happened was that after the official left, and that Jose was then giving more directions, Erik was in such an emotional state that he turned around and told his father to shut up. And he said it very loudly, and it stopped everybody around the whole courts. Now, you may remember Brian Anderson tells the story very differently. He says that not that Erik says anything in the middle of play because Jose is haranguing him with these directions. He says that it's after it's over and Erik has lost and Jose has gone over to talk to him, Mr. Reasonable Man, going to talk to to communicate with his son. And it's at that time that Erik says to Jose, after play is over, shut up. But this is how Pat Anderson remembers it. And it's a very dramatic event, which is, I suppose, why she remembers it. Okay. And he said, stopped everybody around the whole areas. There were games going on. There were like 15, 20 games going on. And what had happened was it was so loud that it shocked everybody. And Jose, with that, then threw up his hands and just said, I'm washing my hands of everything. I don't want anything more to do with him. I can't stand this. He doesn't listen to me. And he said, that's just it. Now, maybe this is the opening round in the declaration of war. Kitty, in the meantime, keep in mind, Karen Farrell, where winning and losing don't matter. Kitty, in the meantime, sitting next to me, was just a nervous wreck. I mean, she had the tenseness of gripping her hands and grinding her teeth to the point where she was actually white from nervousness. And Miss Lansing points out, you just made 2 fists. And the answer, 2 solid fists. And then I cannot do the exact, but she would just grind her teeth like that. And that's how she was. But she was also very, very, very white. Because by that time, she had been holding her breath and everything because of this incident that had just gone on. Erik had then lost. And then in the meantime, Jose had just left us for just a few moments and came right back, only to discover that, of course, Erik was losing. And he was then very, very upset. How did he demonstrate that he was very, very upset? He went into the court and he actually was pulling Erik out of the court and just even left his bag and everything on the court and was so upset with him. And then I was sitting right there, and as the door was right there in front of me, I was going to go up to Erik and say that, he tried his best. He really did try his best. But with that, Kitty pulled me back again, the same type of thing I experienced many times with Lyle when we had gone to the different meets, that I was not to go up and talk to Erik at all because his father was there. And you remember Brian Anderson's testimony? Oh, Kitty ran over to her son and consoled him that he had lost. Did you feel sorry for Erik? Yes, I did, extremely. He was like a little bird that lost his wings. I mean, he was very upset. And he was scared. And the fright in his face was you just didn't miss it. Now, what's he scared of, folks? It was there. Jose pulled him off the court and pulled him right across all the other courts and took him up the stairs. We were on the lower level of the tennis areas, and he pulled him up. By that time, Kitty went out to collect everything off of the tennis court, and we then followed. Now, in either of these circumstances, because Mrs. Anderson had described a previous year when Lyle was playing, and a very similar thing had happened. In either of these circumstances, did Kitty try to step in and intervene between Jose? No. And I think either one, and the transcript says either one of Erik, but I'm sure that's a reporter error. Should have been Lyle or Erik. And the answer, never. So she went on the court and she collected everything, and we then followed her, and we went to the vehicle that we were in. And what happened then? And then we went back to the hotel. Were you all staying at the same hotel? Yes, we were. Usually what happens is that we always went to support the boys in the meets in Kalamazoo because we lived in Chicago at that time. And what would happen is Kitty would get us, and what she means by that is they didn't live in Chicago. You heard Mr. Anderson testify. They lived in Downers Grove since 1970-something, but she's divorced and she lives in Arizona now. So I think that's what she means. And what would happen is Kitty would get us a room not too far from their room on the same floor. So you all went back to the hotel room. Yes, we did. Was this in the morning or late? And that's all I've put on of her testimony. And you recall that what she then goes on to talk about, which I talked to you about earlier in the argument, is what happened around dinner and Erik not coming to dinner. So this is what's going on that summer, and not any misbehavior on the part of the defendants, that on the part of Erik and Lyle, that they're reacting to. This is parental warfare and not business as usual. Parental warfare that's escalating. Why? Because he lost a tennis match. And in that family, that's enough to bring out extreme behavior. I'm going to take this down because it's one thing on here. And this is Dr. Cox, and I'm going to get to this in a minute. Now, I'm sure that Mr. Kuriyama will get up and say that I have engaged in character assassination of Jose and Kitty Menendez, and I'm trying to distract you from the issues of the case. So let me read you some instructions. Because the fact of the matter is, the character, the aspect of the character of Jose and Kitty Menendez that I have been talking about is properly before you in this case, and in fact is the basis of certain instructions that you're going to get. It is not only relevant, it's critical in order to evaluate this case. And here are the instructions that you're going to get about this. Evidence has been received which may tend to show that the decedents engaged in acts of violence and abuse on occasions prior to August 20th, 1989. Such evidence may be considered in deciding whether the defendant had an honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury or the commission of a forcible and atrocious crime. You are also going to be instructed that one who has received threats against his life or person made by another is justified in acting more quickly and taking harsher measures for his own protection in the event of an assault, either actual assault or threatened assault, than would be a person who had not received such threats. If in this case you believe that one or both of the deceased made prior threats against the defendant, and that the defendant, because of such threats, feared greater peril in the event of an altercation with one or both of them, you are to consider such facts in determining whether the defendant acted in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. So the issue isn't character assassination. The issue is, what were they like and what did they do? Now, see, if I stick to this, I take less time and ramble. Ooh, all those pages gone. Okay. Now, there are some things that Mr. Kuriyama mentioned in his opening that I haven't addressed in my remarks to you. Most of them, I think, were covered just in discussing the evidence, but I'm going to go back and see if there are any things that as yet are not covered. He was trying to talk about the good qualities of Kitty Menendez and the good qualities of Jose Menendez, and I've addressed that briefly, but let me just say this. If Jose and Kitty Menendez had married and had not had children, then I think there would be a completely different way of looking at them. They both had many personal qualities that we consider positive, and I've mentioned what some of them are. And I can imagine that if Jose Menendez, without children, in his particular style of dealing with people, which was so power and domination oriented, could have lived a perfectly successful life, taking out this need to dominate at the office and on his wife, and none would have known and nothing tragic would have happened. And if Mary Louise Menendez had fulfilled her early desires to have a career and to have an identity based on her own accomplishments and not just be the wife of a successful rich man, she may have had a happier life and there would have been no tragedy. because these are not, in an absolute sense, the worst people in the world. They are just people who never, ever should have had children, but they did. And that's where the tragic part happens, because whatever their pre-existing problems, whatever their backgrounds that led one of them to be such a power junkie and the other one to be so angry at life, whatever that was, all of that dark side came out towards their children by the fact that they had children. And that's really the tragedy here, that they're not totally worthless individuals at all. It's just that they set in motion, by being so terribly wrong to be parents, the series of events that eventually killed them. I guess I will just give a passing remark to the BBC. I guess when you run out of any other theory that the money they did it for the money, or they did it for hatred, or they did it for control, I guess now it's the movie made me do it. And that's such a strange idea, particularly since I don't know, and Mr. Curry, we don't know. Neither the prosecution nor the defense has any idea if any of you saw that movie, the BBC movie. Okay, now you're supposed to decide this case based on the evidence presented in the courtroom. And so I have no idea if any of you are walking around with the facts of that in your head or what that does. But I can talk about the evidence, and there is no evidence presented in this case that shows that first of all, that Lyle and Erik were together at the time the movie played. There is evidence by his own testimony that Erik was in Florida on the 30th and 31st, but there is no evidence that Lyle was. So the fact that the movie showed in Tampa doesn't tell you very much. Beyond that, there is no evidence that there is any facts in that television movie or even in the real life story and cases of the Billionaires Boys Club that bears any resemblance to anything that happened here. Okay, so it's just a totally specious notion, and it is an Ozilism. And the reason we know that finally is through Judalon Smith's testimony. And just this little piece of Judalon Smith's testimony, I think you can completely rely on because she's got the phone records to back it up. She says that Dr. Oziel she tells us that Dr. Oziel was completely familiar with the Billionaires Boys Club movie because he was watching it on the night of the 31st, and she's on the telephone with him, and he's talking to her about it, and there's her telephone record, which shows she is on the phone to his number, okay, or he has called her. It's from his record, and it shows the length of the call, and it is during the time that the movie is showing. The movie shows from 9 to 11, and this is 10:36 or 10:26, something like that. And the phone record is in evidence. So the notion is Erik Menendez didn't tell Dr. Oziel anything about a BBC movie. When Dr. Oziel's trying to put this together, he remembers full well, because he watched it, that a few weeks before the parents were killed, that movie played. And in his desire to set up his little blackmail scheme, he plugs that in, period. It is also, I submit to you, a ludicrous idea that Erik Menendez would see this movie and suddenly the light bulb, gee, Dad's bad, I should kill him, which is the theory of that. For one thing, I don't think it works that way. I mean, he's living in America in a television world. I don't think the idea that a child can kill a parent has to come from a movie, has to come from that movie in which you don't have any evidence that the child in that movie actually killed the parent in that movie. The only thing you know, he was somehow involved in the killing of a parent. And I can't talk to you about the facts of that movie because they're not before you. And if you have them in your head, I don't know what you're supposed to do in the jury room with them, because I guess you can't talk about them either. I don't know. I don't know how you're supposed to handle that because it's such a specious piece of evidence to begin with. But just to put it to rest, why would Erik Menendez have to see a movie about the BBC to inspire him to kill his father? This is supposed to be the operational event because the people have no crisis. Without the revelation of the molestation secret, people have no reason why this family is in crisis so that this could happen, okay? Erik Menendez went to school with a young man named Brian Eslamina. It is Brian Eslamina's father who was killed, theoretically, by members of the Billionaires Boys Club. Okay? Erik knows him. And he knows him from 1988. And he knows this family's story. And he's always known it since 1988. And obviously Craig Signorelli knows about the BBC, and he doesn't even go to Beverly Hills High School. Okay? So this is a known thing. So how in the world, if he already knows Brian and he already knows this family, would this movie on July 31st mean anything whatsoever? Well, obviously it wouldn't. That can't be the causing factor here. That's nonsense. But it certainly appealed to Mr. Kuriyama because he brought it up at every opportunity in this case. The other thing Mr. Kuriyama said in his opening, which is not based on evidence, is he kept talking about how the brothers, this indistinguishable mass, threatened Dr. Oziel. And there is not one shred of evidence, and never has been, not even in anybody's previous memory or anybody's previous inconsistent statement, that Erik ever said anything threatening to Dr. Oziel. He went to Dr. Oziel because he was on the verge of suicide. And Oziel did testify. Erik never threatened me. Erik never said anything threatened. He chose to have somebody in his office to listen into his patient for whatever his reasons were, but not because Erik had threatened him. And that is clear. It could not be clearer. Erik never threatened him, but the prosecution has a great desire to paint Erik with this black brush, even for things he never did. Mr. Kuriyama fantasizes and speculates that there was some kind of conflict in this family because Erik didn't want to follow the rules of the family or toe the line. Which rule is it that Erik didn't want to follow? I'll tell you which one it was. Get on your knees. That is the family rule he did not want to follow. And there is no other rule that Mr. Kuriyama can point to that Erik violated, either that summer or any other time. Okay. Now, as I've told you before, the prosecution, under the notion that they have the burden of proof, gets to argue twice, and I only get to argue once. And so I won't be able to answer what he's going to say. I may have already answered some of it in my argument now, but I don't get to go up again. However, there are some things that I can anticipate maybe he'll say. I've already done some of them. Okay, let's talk about the state of mind at the time of the shooting. We have presented evidence for you that what's happening here is this automatic fight-flight limbic system. This takes over, as it does in any kind of emergency situation with anybody. And then the prosecution may say, well, if that's true, then how come so few minutes later they're able to think there's fingerprints on the shells and pick them up, etc. And Dr. Burgess testified about the different stages of this fight-flight automatic impulse system. But I think it's no different than what I talked to you about before with the near miss with the truck. Fear is one of those emotions. When you're instructed about cooling period and heat of passion, you'll see that they talk about emotions that abate and there's a cooling period. Fear is not the kind of emotion that cools on its own. Anger, you can get angry and nothing can intervene at all, and eventually the anger will die down. But when you're fearful and the situation provoking the fear is continuing, okay, the fear doesn't go away until the threat is over. And in this case, the threat is over after the shooting. We've obviously gone past break time here, Judge.
We've gone beyond the hour estimate, too.
No, I didn't say the hour. I said
You
this
said
morning.
1 hour. You had about 1 hour to go.
Oh, yesterday.
Yesterday.
Yes, but yesterday I was too tired to know better.
Yes.
When you get tired, you know you get dumb.
Well, now that you're not tired, how much longer do you think you have?
I have enough that it pays to give the jurors a break.
How much longer do you think you have?
If I get to have a cigarette or if I don't.
How much longer do you think you
I'm
have?
looking, Your Honor. I'm looking at my notes. I think I have about half an hour.
Okay, 30 minutes.
Yep.
All right, we'll take a recess, ladies and gentlemen, and we'll resume for the final 30 minutes at 10 minutes after the hour.
I wrote down idea. I was talking before when we all went off to have our drugs that the prosecution may argue that Erik could not have been in this state of complete non-thinking panic such that he could not have even intended to kill at the time of the shooting if 3 or 4 minutes later he's able to think in terms of picking up the shells. And I think that that's obviously contrary. That argument is contrary to our own experience, because once the threat is gone, that's when the thoughts start flooding back. And after the shooting is over, that's when they go through what Dr. Burgess described as the numbing period, and the thoughts are able to come back and you're able to do cognitive thinking. Not that they did thinking on any great level or put together a very rational tale afterwards, but nevertheless, they were at least able to measure what's happening and figure out what they should do, and that they should say something and that they should come up with a story for the police. And if you recall, it was a very small story. Its parts only had to do with being at a movie theater while the shooting was happening, going to meet someone at Taste of LA, albeit they were late, stopping off home to get false ID, which is the explanation for why they were there, and parking the car in the back before they left the house that night. And that was the whole big elaborate tale, which certainly doesn't sound like something that you would have had to have planned in advance to come up with. And I wanted to focus just briefly on the notion of intent to kill, because intent to kill is the difference between involuntary manslaughter and voluntary manslaughter, and intent to kill is also the express malice component of first or second degree murder. And I have argued to you that there is no direct evidence here, and that is true, that Erik Menendez intended to kill either parent. There is evidence that he assisted his brother in the reloading process, and I submit to you that that too is not evidence of intent to kill. And if you read the aiding and abetting instruction, which is all that he's doing there, because remember, he doesn't even go back. When Lyle goes back into the family room den, Erik does not. Lyle leaves first, he goes in the room, Erik hears a shot, and he sees Lyle coming out of that room, and he has not gone back in. And I think that fact informs whether he intended to kill or not. But I think in actually analyzing what happened here, given the chain of events and the rapidity of action and the state of panic that he was in, you have to assess intent to kill from the moment when they go into the room. And I submit to you, when you're operating on a survival instinct and your only thought is, don't let someone kill me, that is not intent to kill. Now, what I was addressing before we took the break were some of the things the prosecution may argue that I will not have a chance to answer, and so I'm going to try to anticipate them. And one of them is this, and it has to do with the tape of December 11th. I want you to recall, and if you can't recall without hearing testimony about it, then I would ask you this. Most specifically, I can't direct your deliberations, and it would be improper for me to try to do so, but I would ask you this one thing. If you want to use the tape of December 11th to decide any significant issue in this case, I would ask you, besides obviously listening to it, because I think it's important, and listening for Erik, it's important that you hear how he sounds on that tape. The other thing I would ask you to do, if your notes are not adequate, is to have the testimony of Dr. Burgess concerning that tape reread to you. Because one thing you do not know in any detail is what was going on between Erik and Lyle and Dr. Oziel before that tape was turned on. It is obviously turned on in the middle of a conversation. And Dr. Burgess has information that she testified to that it is clear that Erik did not trust Dr. Oziel. It is clear that he thought Dr. Oziel was trying to blackmail him. It is clear that he and Lyle had determined they were not going to tell Dr. Oziel the secrets of the family. They were going to go along with what he wanted, give him what he wanted to the extent that they could. And Erik wasn't even able to do that, really, during the session of December 11th because he was too upset. And so he stayed out of the conversation by and large. And when Dr. Oziel tried to drag him in, All he could talk about was his regret and his remorse and his love for his parents. And you cannot take that tape on face value, because you know that the people participating in it, at least Erik and Lyle, are not intending in that tape to be truthful. But as is characteristic with Erik after the killings, his guilty conscience is such that the truth keeps coming out in hints and suggestions. And of course, Oziel's not interested in that, so there never is any follow-up. But there may be some suggestion by the prosecution that they made this tape. I mean, I think Mr. Kuriyama even made reference to it in his opening. He claimed, and he is in error. And remember, it's been 5 months of testimony, and I may be wrong in my recollection of some of the facts that I've talked to you about. And Mr. Kuriyama he certainly thinks I am. That's why I kept objecting. And Mr. Kuriyama may be wrong in his recollection of the facts, but there is a record, and you are ultimately the determiners of what are the facts of the case. You can't apply the law until you first decide what the facts are. But he says that there was testimony from Judalon Smith that somehow Erik and Lyle were supposed to express remorse on this tape. And there's no such testimony. How would she know that anyway? But there's no testimony that Dr. Oziel told her that that was the purpose of making the tape. All we know is that Dr. Oziel suggested in one of the earlier sessions that he, being the genius that he is, could piece together the family constellation. Nothing about remorse. And I submit to you, there is no way Erik Menendez was, at this point, after the way Dr. Oziel had behaved, was going to make a tape for the purpose of it being helpful to him should he get arrested, or for the purpose of staging some remorse. Mr. Kuriyama kept referring to Erik as an actor, and yet you've heard that his behavior and his emotionality is consistent over the entire course of his life. When Erik testified, he was not highly emotional, so I imagine Mr. Kuriyama can't now call him an actor for his testifying. And I think in trying to analyze his testimony, you should keep in mind that no, it is not an actor you saw on a witness stand, but it is the tennis player, the kid who has to go to work. And this was the greatest challenge, if you will, of his life. And he knew he's going to be on the witness stand, and he knows he has to function, and he knows he has to give answers. So he went to work, and he was not highly emotional. And I would have frankly preferred that he was. But he did what he could do, given the fear. I mean, and it is, we're all nervous. I was nervous examining him, but it is terrifying to be up there. And it is terrifying when you have to overcome everything that has happened to you in your life. And I hold it as a great testimonial to the skill of Dr. Vickery, that he took a complete basket case, who clearly could have never even been a witness in his own case, in the condition that he was in 1990, and got him healthy enough that he could do what he had to do in testifying in this case. The prosecution may argue that Erik and Lyle were not truthful about how much clothing was dumped. I'm not operating a complete vacuum here and suspecting what may or may not be said, but I would point out one thing to you, and that is this. Erik testified that he got rid of his pants because he saw these little dots of spray on them. Lyle did not have that on his pants, apparently, because he didn't change them. Now, they may argue, oh, this was such a scene of carnage. There had to be blood everywhere. It had to be all over them. And I will point out to you the one fact that disproves that. You have all the photographs of the house. There is no blood tracks anywhere. There are no drops of blood outside that room. If they had been covered in blood to any extent, there would have been blood evidence outside, took down all the pictures, but outside the area right around the couch. And there is absolutely none. No footprints, no drops, nowhere in the house, nowhere near the guest house, nowhere upstairs in Erik, nowhere. All the blood is right there concentrated. So what he's talking about is these tiny little sprays and nothing else. And so it is not unbelievable or untruthful that one of them could have had that small evidence of blood and nothing greater. One other thing I want you to keep in mind, if Mr. Kuriyama should make the argument that our experts only know what Erik told them, and that's not true. I think they made it very clear that in forming their opinion, they read everything. They read the statements of all the witnesses who were called, the statements of witnesses who were not called to testify, all of the previous testimony, all of the medical records and the school records, so that when they came out with an opinion about whether Erik was indeed an abused and molested child, it was not based on what he was telling them, but was based on the entire picture of the family that they were able to formulate, that you're able to formulate based on what other people said. And finally, I want you to remember in evaluating the molestation evidence how very, very secretive this family was. How the relatives who lived closest to them knew nothing about the reality of their family life, knew nothing about the reality of their children. They were told they did fabulously in school. They didn't know differently. Neither child ever betrayed that secret. And the little cousins who stayed in the house over the summers were kept away from their room whenever Jose was alone with them. And so if the argument is made that this molestation could not have gone on in this house, when the cousins are there, I submit to you that the kinds of things that Jose Menendez was doing to Erik don't make a great deal of noise. And the few times that he did assault him in such a way that the child screamed, he made sure there was nobody home to hear it. Mr. Kuriyama said to you, which is entirely proper, that he felt privileged to represent the people of the state of California in this case. He is a district attorney, he is a member of the government, and he likes his job, and he does a very good job of it, and he works hard, and I think his sentiments are completely appropriate. I cannot stand here, though, and tell you that all I feel is privileged for having represented Erik Menendez for 3.5 years. I'm aware of the fact that besides wanting to comment on all of the evidence, I've given you a very long closing argument because I don't want to let go of him. Since Erik became my client in March of 1990, in the condition that Dr. Vickery described to you, it is more than being privileged, and it was more than just a task of representing him to be able to put this trial on. There is no way that you can go back and share the experience of a 19-year-old, which is what he was at that time, without getting more than somewhat professionally involved. And I admit to that. And I admit to an enormous bias in favor of this client. And as you know, his family was always kept distant from him, and were physically and are physically distant from him. And there was that sense in those early days that I was the only person he had. And for 3.5 years, I have definitely felt, shared somewhat by Miss Morrissey, shared, I'm sure, also to some extent by his doctor, Dr. Vickery, that we are responsible for Erik, and we have had him in our hands all this time, and now I have to give him up to you. And the minute I am finished, he is out of my hands, and whatever happens to him depends on what you do. Now, he has not had a great deal of positive experience with adults who have been responsible for his life. I take it as a great compliment that it seems to me, and I think it was something that could be seen throughout this trial, particularly when he testified, that in spite of the type of childhood he had, he has finally learned to trust someone who has control to some degree over his life. And I have to trust you, as Mr. Kuriyama has to trust you, to fulfill your duty as jurors here and to judge him under the law. We have talked about a lot of things in this case, and some of the things that I've talked about in my argument are moral arguments. And there are a lot of things that could be said about the morality of what happened here. But it really is not your job to make a moral decision. For example, issues of holding people accountable on individual responsibility is a social and a moral issue. But if you were to convict Erik Menendez of murder, you wouldn't be teaching him a lesson in individual responsibility. You would be ending his life. This is not the place to teach people lessons that they should have turned out better in spite of what happened to them. What your job is to follow the law as the judge gives it to you. And legal responsibility is a different thing than moral judgment. The law does not expect people to be perfect, and the law does not impose its penalties in order to teach moral lessons. Now, the other thing I want to tell you is this. You are being given a choice of 5 possible verdicts on each count, and I'm not going to give you a lecture on the law. But each decedent is a separate count, and for each decedent, you are being given a choice of 5 different verdicts: first-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter, and not guilty. And that is true as to each. And you have to analyze the evidence as to each separately. And you have to make those decisions as to each separately. And this is a very complicated trial. And there is very polarized evidence in this trial. There is no real compromise with the evidence here. Either you accept the defense version of the case in its essential parts, or you accept the prosecution version. And there is no way to compromise this evidence. Either this is a murder because everything we have told you is not true, and they killed for reasons unproven but completely different than what we say, in which case it is a killing with malice, or it is a killing that resulted from the things that we have told you about, and that it was done under a state of fear. And if that is true, there is no malice, and it can only be manslaughter. Now, my concern is, because this is such a polarized case, you may find in your deliberations that you are polarized. The one thing, we all want a verdict. Obviously, we've worked very hard. There's been a lot of time and effort here, but we do not want a verdict if it means that any individual juror sacrifices their own properly held view of the case. And what I mean by that is, it is not proper to compromise. If you believe the case requires a particular verdict and you have deliberated with the other jurors and you have considered all the evidence, you have to stick to your position, even if it means there will not be a verdict, there will be a hung jury. That is preferable to compromising both sides' right to have the individual opinion of 12 separate jurors. You are 12 individuals, you are not a unit. And although you may all be friends, and maybe that will even survive deliberations, nevertheless, that is your duty as a juror. And one of the reasons that apart from the fact that that's the constitutional right to a jury, the other thing too is something very tragic has happened in other cases that I'm sure Mr. Kuriyama and I both know about over the course of our experience. And that is, you are being instructed that you must not consider penalty and punishment. And that is true unless we wind up in a second trial here, in a penalty phase. The reason for that, well, there's all sorts of reasons for that, but it's not your job. That's the judge's job. And juries in the past have made the tragic mistake of thinking they knew what the penalties or punishments were for various offenses and thought they were making compromises for that reason. Let me assure you, you do not know. It should never govern your decision to think you know. You should not consider that if you decide the case a certain way, that you will have any influence whatsoever over sentencing, because you won't. That is solely the province of the judge. And I want to remind you of that. And I particularly want to tell you that your decision is whether it is a killing with malice or without malice. And it is improper to try to compromise by saying, well, I can't decide that issue, so I'll only find second-degree murder. That is a disaster. And I would ask you not to do that. Either you accept what we have proven to you, or you do not. But you do not compromise, because you do neither side any good in doing that. I have had a fantasy since the day I started representing Erik. If people were to ask me after 3.5 years of thinking about him in this case every single day somehow or another, even on vacation, what is it I want out of it? My answer is not necessarily a legal one. There's only one thing I actually could focus on that I wanted. I want to see him walk down a street, not in chains, not in shackles, and not with a deputy sheriff standing next to him. Now, to fulfill my dream and my fantasy, you'd have to come in with a verdict of not guilty. And if you don't feel you can do that, based on the instructions that you're getting, I would ask that you come in with a verdict of involuntary manslaughter, because I believe that's what the evidence shows. And I think all of you will discharge your duties as jurors in this case with great diligence. You have been a remarkable jury, extremely conscientious in being here, in paying attention. It was nice over the last couple of days to see you smile a bit, because we have thought of you as the tough jury as compared to the others who we thought of as the soft jury. But that's all based on appearances. And what I have learned, and what I'm sure Mr. Kuriyama has learned over the years, that nothing can trip you up worse than thinking you know what jurors are thinking based on whether they smile at you or not. There are many war stories, and when it's all over, I may share them with you, that is the easiest way to get misled. But certainly if you're standing in front of people for 2.5 days, it's very nice when they're responsive. And I thank you.
All right, thank you. Are you ready to proceed?
There is a matter I'd like to take up on one side of the business. And you have to get,
All right. Well, let's do this, ladies and gentlemen. We'll take a recess and we'll resume at 1 o'clock, and then we'll get started since it's 11:35 or so, and give the lawyers a chance to get organized here for the final argument of the prosecution. And we'll ask that you all return at 1 o'clock. Don't discuss this matter with anyone. Don't form any final opinions about it. Let me say a few other things. There are a lot of people in the audience and a lot of people watching this trial in the courthouse. They all have some interest in the case, or they wouldn't be here. It's very important that you not have any contact with any of those people, because they might want to ask you, well, what did you think? How do you react? What are you thinking about all this? That would be entirely improper, and it'd be entirely improper for them to ask. It'd be entirely improper for you to answer. So the best way to deal with any such situation is not to have any contact with anybody in the courthouse whatsoever. You have enough friends on the jury to talk to them. And obviously, you must not talk at all about this case until it's finally given to you for your decision. We'll see you all back here at 1 o'clock today. All right, yes.
Your Honor, with respect to my argument, there's a couple of questions that I have. Want the guidance of the court. The defense has argued that the defendant was available to us, that we could have interviewed him for 50 hours, just like the defense did. That was never ruled upon, and in fact, the defense had made the statement that they would not allow that. So I wanted to get some guidance from the court as to how I could handle that argument.
Well, just so the matter is put in its proper context, the people filed a motion to have the defendant examined. The people cited a recent California Supreme Court case that the people felt supported the position that the examination could be conducted. The defense informally indicated opposition to the motion. The motion was never pursued by the prosecution, and the matter was dropped as far as this court was concerned, since you never pursued it. But it was the people's position that you had a right to conduct such an examination. That's basically what happened.
That's correct. There was no ruling on it.
There was no ruling because you didn't ask for a ruling.
Well, the defense had indicated that they refused to do that.
Well, that's good, but you never asked for a ruling. You never put it to a test. So that's basically where it sits.
Inasmuch as there was no ruling, and he certainly didn't volunteer to come and be interviewed by our experts, that was inaccurate to that degree. So I just wanted to let the court know that I will address that in my closing argument.
I'd like to let the court know that the reason, they didn't pursue it, but we thought we gave an informal opposition because we felt that the authority, both the case they cited and other cases, would have permitted it, frankly. And that's why we didn't brief it, because they couldn't find the authority for a position. And they certainly could have asked for a ruling, and I suspect the court would have granted their request. But they chose to proceed without experts. And if Mr. Kuriyama gets up there and starts talking about we asked the court for a ruling, I would object, because I think that's improper argument. The fact of the matter is, based on the authority they cited, had they asked for a ruling, had the court granted it, they could have sent somebody in there to interview him for 50 hours. I think their problem is they didn't have an expert that could help them. And that's why they didn't use it and didn't pursue it.
The inaccuracy
Now,
is
we
that
know their experts sat in this
Okay, let's
courtroom.
not argue about things beyond this limited issue that's before this court. The ultimate concern would be whether or not the prosecution could remark on the right of the defendant to refuse to speak with the psychiatrist or psychologist, regardless of whether there was an order compelling him to do so. It was my impression, quite frankly, that that's really what the prosecution was seeking, just to have the court order and the defendant refuse to cooperate, and then you would use that in some fashion as a issue showing consciousness of guilt or refusal to cooperate, something along those lines. That was my impression, but you never pursued it, so it never came to a head.
And it was our position, which, because it was never pursued, we didn't have to show it, but after we had researched the issue, that if the court had granted it, our client would have cooperated so that we do not get that. So what could be said about it now? He didn't object when I made the statement.
I did object. It was overruled.
There was an objection.
Well, then
There was an objection. The court overruled it because I was aware of this history
Okay.
that we've just been discussing.
So in other words, the defense had already indicated that they would not cooperate, and then she has the nerve to argue that he was available. They never volunteered him to
Well,
be
that's not
interviewed.
their job to volunteer.
I know,
It's your
but
job
for them
pursue it.
for them to argue that is not true.
Well, counsel, as I said, the issue was that you had made a request or filed a motion to have the examination. You never pursued it, so it was never resolved. And we don't know what ultimately would have happened.
That's my
The
point.
bottom line is, it's true that we don't know whether or not the defendant would have or would not have cooperated. We'll never know that. That's one of those mysteries that we'll never know the answer to.
We know that the only expression we got concerning whether or not he would cooperate was a negative one.
Well, that's all outside the record.
So was what she argued.
No, she said that you had a right to examine the defendant, and you didn't do it. That was your position. You had a right to examine the defendant. You filed a brief supporting cases saying you had the right to do it.
I'm not sure if that is exactly how she phrased her argument. I'll have to check that. But notwithstanding that, we did not have the right. We were not given that right by the court because the court did not rule on that.
Well, you didn't ask for a ruling.
That's my point. There was no ruling on it, so how can she say we had the right? We were not
because
given
you
that
said
right.
you have the right. You said it. You said it when you filed your brief. You filed a brief and you said you had the right to do this, and this is the legal authority for that. And you wanted the court to issue an order in that regard, and the court didn't do it because you never pursued the matter. It was just dropped. I didn't know why you dropped it. I have no way of knowing when things are not pursued as to why they're not. They just, you file papers and then you forget them. So I don't know. And I had no way of knowing why it is that you didn't pursue the matter, but that's the way it is. But your position was that you had an absolute right to have the defendant examined. So she referred to that in her argument. She's just reflecting what your position is. You're not disputing that you had a right to examine the defendant, are you?
We made that motion and it was not ruled upon, so I don't know.
I thought when you filed the motion, you cited a case and it was your position that that was a legitimate position and you believed that it was correct.
Personally, I didn't file the motion, Mrs. Bazanich did, but that was our position.
Okay.
In fact, that was our position.
Okay, well, then that was your position. You had a right to do it. And you
However,
didn't.
just to make a point, I could have filed a brief saying that I had a right to interview him myself, which I don't have. And the fact that I said that I did in a motion doesn't mean that I have that right.
Well,
The fact that
I assume you wouldn't do that because it wouldn't be a correct statement
that's
of law.
correct.
And you filed something that you believe was a correct statement of law.
At the time, Mrs. Bazanich did, yes.
Okay.
So
and you have some reason to believe that that wasn't correct?
Well, I believe she had the authority to ask for the examination. The defense indicated they wouldn't. I don't think that we could have forced him to submit to an examination.
That's absolutely true. You couldn't.
Yeah. So
That's
for
true.
her to say that he was available when they've represented to me that they weren't going to make him available is inaccurate. So I just want to comment on that.
Well,
that they never. Okay, this is accurate. They never offered him, never volunteered that we be able to interview him. That was never never done.
They're not obligated to do that. Why should they do that? What would be their reason to volunteer?
Well, they definitely didn't have a reason to do that, and that's why they indicated that they wouldn't do it. But for them to argue to this jury that he was available when he was not available, they didn't make him available. There was no court order allowing us to even try to interview him. So that's the issue.
Okay, I've indicated the posture of the matter as to how it developed and the context in which the courts has overruled the objection by the prosecution to that remark. And based on that, it would be improper for you to argue that the defendant could not have been examined, since it was your position that he could have been examined.
I wouldn't argue that he could not have been examined. I would just say that they never volunteered to have him examined.
Again, that's not within the record, one way or the other. So you can't argue that. It's not in the record.
Come back at one.
Okay. Well, the fact that we had filed a motion was not before the
I've
jury either.
already told you what my feelings are. If you wanted to find the specific reference in the argument that was made by Ms. Abramson, I'll be glad to look at it.
Okay.
If you want to spend your time doing that. What other matters did you want to
There was
discuss?
one other matter. There was a defense witness who they attempted to put on a Dr. Summerfield. They decided, based on my indication that I would cross-examine Dr. Summerfield on Mrs. Menendez's statement that she had information that the defendants were sociopaths and that she feared them and that they lacked a conscience. They decided not to put on Dr. Summerfield, but Mrs. Abramson argued statements apparently made by Dr. Summerfield in her argument that were never in evidence.
Well, were in evidence. They came in without objection during Dr. Tyler's testimony, in fact. I was very careful, and they came in for all purposes because there was no limiting objection at the time.
Regardless of that, I don't recall you objecting to that in your argument,
Right.
Mr. Kuriyama. So I'm not obviously going to do anything about that now, and it doesn't open the door to your introducing other matters that have not been presented during the course of the trial.
Those are the two matters I wanted to take up.
All right, we'll be in recess until 1 o'clock.